Hi, and welcome to the May 2021 episode of my PIP Monthly. My name is Amber Holloway, and I'm a partner here at our Troy office. Our May 2021 topics include, of course, the case law update. First, we will discuss the case of Pioneer State Mutual Insurance Company v. Andrew Lynn France, then the Advanced Pain Care Center v. Trumbull, and lastly, the Johnson v. Geico Indemnity Company case. And then we'll move on to trending topics in PIP litigation, and this month we will talk about the independent verification of loss that is required under the No Fault Act and summary disposition motions relative to the same. Up first for our case law update, we have the opinion of Pioneer State Mutual Insurance Company v. Andrew Lynn France, which was issued on March 11, 2021. The big takeaway from this case is that intent is irrelevant when analyzing the issue of innocent misrepresentation. Also, it's important to note that a finding of a fraudulent misrepresentation may be supported by circumstantial evidence rather than direct evidence only. By way of background, this case arose out of a DEC action filed by Pioneer State Mutual Insurance Company against Andrew France. Pioneer was seeking to declare the subject policy void and also seeking an order that Pioneer had no duty to defend nor indemnify France in an underlying tort action. The tort action was actually filed by France's daughter against France and the daughter's friend who was driving the vehicle in which France's daughter was a passenger in during the subject accident. France's daughter also sought PIP benefits from Pioneer, and during the investigation of that claim is when Pioneer discovered that France's daughter was not a named insured under the policy. Pioneer then filed a DEC action asking the trial court to declare the policy void and therefore declare that plaintiff Pioneer had no obligation to defend defendant or indemnify defendant in the underlying tort suit involving his daughter. And Pioneer also asked the court to grant rescission based on defendant France's misrepresentation of the number of drivers driving the insured vehicles garaged at his home. The parties were able to agree, or it was undisputed, that France failed to disclose that his daughter was a driver of one of the insured vehicles when applying for insurance and during the supplemental insurance response period. Due to the same, the trial court granted Pioneer's request to rescind the policy issued to France. On appeal, France argued that the trial court's ruling was erroneous because there was no intent to defraud. The court disagreed, noting that France testified that he purchased the vehicle in question for his daughter and that she was the primary operator of that vehicle. Those details were not disclosed to Pioneer before the accident. The court also found that whether France's daughter lived in the household or not was irrelevant to the failure to disclose, given that she was a regular driver of the vehicle. That failure to disclose impacted the insurance rates given to France by Pioneer. The court argued that the actual intent in making the misrepresentation was irrelevant to establishing an innocent misrepresentation. And it was also irrelevant as Pioneer relied to its detriment and provided those insurance rates based on the misrepresentation. With regard to a finding of a fraudulent misrepresentation, the court deferred to the trial court's function of assessing the credibility of the witnesses. For example, there was evidence that France knowingly omitted his daughter as a driver when applying for insurance with Pioneer. In sum, the lower court did not clearly err in finding intent to defraud based upon the circumstantial evidence. The court also highlighted that France's claims that he never read the insurance policy that he signed himself was no defense to a DEC action. The court then turned to the issue of rescission and opined that the trial court must conduct a hearing consistent with the Bazzi v. Centennial case. According to Bazzi, there is a balances of the equities that is required to ascertain whether rescinding an insurance policy between Pioneer and France would be equitable, as it would affect the innocent third party or his daughter. In conclusion, the court reversed the trial court's declaration that Pioneer had no obligation to indemnify or defend France and the underlying tort suit, and remanded the matter to trial to conduct a hearing under BASI to determine France's rights for defense and indemnification. Next up, we have the case of Advanced Pain Care v. Trumbull Insurance Company, which was issued May 13, 2021. As you all probably know, a lot of the controversies surrounding provider cases such as this one was resolved in the Covenant Medical Center v. State Farm automobile insurance case in 2017. Nevertheless, two issues are still frequently litigated. One, assignments, and two, the issue of the assignment on a patient's settlement of the provider's claim. Both of these issues were addressed in the Advanced Pain Care case. Advanced Pain Care's patient, James Baltimore, was injured in a July 2018 accident and thereafter sued Trumbull Insurance Company. It's important to note that Trumbull was represented by Seekers Warder on appeal. Prior to the appeal, Mr. Baltimore and Trumbull reached a settlement of all past, present, and future no-fault benefits, and agreed to release Trumbull from any and all liability arising out of the July 2018 accident. Also indicated in the release was a provision that Baltimore himself will be solely responsible for any and all liens, including doctor liens, and would hold Trumbull harmless from liability from any of those liens. Mr. Baltimore also disclaimed and rescinded all prior assignments, whether known or unknown, to Trumbull. Advanced Pain Care filed its own suit seeking to recover based on an assignment executed by Mr. Baltimore. In response to Advanced Pain Care's complaint, defendant Trumbull moved for summary disposition, attaching the Baltimore release. In response to defendant Trumbull's motion for summary disposition, Advanced Pain Care argued that once Trumbull received the assignment from Mr. Baltimore, the execution of the settlement became irrelevant. Advanced Pain Care further argued that once Mr. Baltimore executed the assignment, Advanced Pain Care became the real party of interest, and nothing Mr. Baltimore did after that could change them being the real party of interest. Plaintiff also claimed that Trumbull had notice of the independent claim based upon the fact that the insurer received bills prior to the settlement. Ultimately, the trial court disagreed, finding that the provider's claim was barred by the release because the bills that were provided were insufficient to put Trumbull on notice of the plaintiff's claim. This case is pretty similar to another unpublished opinion we discussed in the maybe the month prior, called Podiatry and Rehab Associates. In that case, which is very factually similar to this one, the panel affirmed the dismissal of the provider suit based upon the insurer's settlement with the underlying injured party. The court found that when the injured person enters into a settlement which releases all claims past, present, and future, the insurer is protected from provider claims from the same accident unless a written copy of the assignment was provided to the insurer before the settlement was entered into. In the Advanced Pain Care case, that was not the issue. The provider did provide bills, however, the bills were insufficient to put Trumbull on notice of Advanced Pain Care's actual claim. Interestingly enough, the court argued that although the provider pled that it had a right to payment for services rendered to Baltimore on the basis of the assignment, to survive summary disposition, the provider had to further demonstrate that it had a right to these payments in lieu of Baltimore having a right to those payments. A medical bill alone does not necessarily put a defendant on notice of a plaintiff's right to collect no-fault benefits on behalf of the underlying claimant. Here, there was no evidence that Advanced Pain Care sent the assignment to defendant prior to the settlement. I wanted to briefly discuss no fault of form and its effect on cases such as this. So essentially, for services rendered after June 11, 2019, a healthcare provider is allowed to make a claim and assert a direct cause of action against the insurer to recover overdue benefits payable for charges for products, services, or accommodations provided to an injured person. However, before June 11, 2019, providers could only bring their own suits based on assignments from the injured person. After June 11, 2019, those assignments are not necessary. However, whether a provider is relying on assignment or direct cause of action under the new statute rules, payment in good faith is often an issue for providers. That's because when an injured person enters into a settlement which releases all claims for the past, present, and future benefits, the insurer is thereafter protected from provider claims from the same accident unless a written copy of the assignment was provided to the insurer before the settlement of the underlying case. In regards to the specific language of payment in good faith, Advanced Pain Care argued that even if Trumbull's settlement to Baltimore was credited against providers' significantly larger claim, Trumbull still owed Advanced Pain Care the remaining balance because the insurer can discharge liability only to the extent of the payments under MCL 500-3112. The Court of Appeals again looked to Podiatry and Rehab Associates, which rejected the nearly identical argument that while the settlement may have arisen out of the claims in the litigation, it clearly and unambiguously released all claims past, present, and future. Moreover, Mr. Baltimore explicitly agreed to pay all unpaid medical expenses from the settlement. And lastly, we have the case of Johnson v. Geico, issued March 18, 2021. The big takeaway from Johnson is that the Court of Appeals permitted summary disposition based on material representations in the submission of affidavits for household replacement service and attendant care services when the services were claimed while plaintiff traveled away from her service providers out of state on multiple occasions during the claim period. Here, the Court of Appeals reversed the trial court's denial of summary disposition, where the underlying claimant essentially attempted to talk her way out of her misrepresentations in an attempt to prevent her policy from being voided. Due to injuries sustained in a 2017 accident, Ms. Johnson alleged that she was unable to perform certain personal care and certain household chores. She claimed that her boyfriend and son assisted her with various services and kept track of those services through an affidavit or attendant care replacement service form. It was thereafter determined that Ms. Johnson had taken several trips out of town to Ohio and Florida, and she admitted herself that she did not take her provider, her boyfriend, and her son to these trips with her. Thereafter, Geico sought summary disposition based on these misrepresentations that these services were being provided. However, Ms. Johnson was out of town. In response, Ms. Johnson argued that the household replacement services were still being provided in her absence, but that the attending care services were being provided by someone else, by her friend and her friend's minor daughter. She attempted to explain that she had accident-related memory issues and that due to the same, she forgot to put the right attending care providers on the submitted affidavits for payments and did not put the minor daughter on the forms on the basis that she believed the providers had to be over the age of 18. The trial court denied the motion, and the insurer thereafter sought leave to appeal, which was granted by the court. The court noted that the attendant care and household replacement services were being alleged while plaintiff was on a business trip to Cincinnati, Ohio, despite her admission that neither one of her providers had gone on the trip. The court specifically rejected the argument that the household services could have still been rendered in her home in her absence on the basis that that was merely speculation. The court found that it's a logical stretch for a plaintiff to claim she required 12 hours of attendant care at her home while she was not there. The court also noted that the claim household services simply did not make sense. For example, the court talked about how Ms. Johnson was claiming that the service provider was cooking for her and washing dishes and taking out the trash. If you are not there, why does someone need to cook for you? Why does someone need to wash dishes if you're not eating on any plates to cause dirty dishes? Consequently, the court then found that the replacement service claims were false and material and independently formed a basis for summary disposition. With regard to Ms. Johnson's claim for attendant care, the court really didn't address Ms. Johnson's arguments that her memory problems assisted in her being mistaken that her ex-boyfriend and son did not assist her with the attendant care during the trips, simply forgot to take them away from the affidavits and add her friend and her friend's minor daughter. The court was very skeptical of this argument and noted that the affidavit failed to explain how or why Ms. Johnson required extensive 12-hour attendant care during a trip. It was simply an affidavit that her friend wrote saying that she provided attendant care during that time period. Consequently, the court found that summary disposition was equally appropriate as to the attendant care claim as well. In sum, the Johnson case affirms the position that not only can attendant care and household replacement service claims form the basis of summary disposition, but they can void the entire insurance contract based on these misrepresentations. Moving on to trending topics in PIP litigation. Here I wanted to discuss the independent verification of loss that's required under the No Fault Act. Pursuant to MCL 500-3105, Section 1, an insurer is only liable to pay benefits for accidentally bodily injury arising out of the ownership, operation, maintenance, or either motor vehicle. Insurers are only required to pay benefits for reasonably necessary incurred costs. Courts have long since recognized what constitutes reasonable proof of loss, and it depends on the benefits sought. Regardless of the type of proof that is reasonable, courts are steadfast in noting that no claim exists without reasonable proof. The Michigan Supreme Court has also addressed this issue and noted that the obligation of a claimant to provide reasonable proof until a specific claim is made, an insurer has no way of knowing what expenses have been incurred, whether those expenses are covered losses, and indeed whether the insurer will file a claim at all. It's thereby illogical to expect the insurer to formally deny as an unperfected claim. That's a quote from the case of Welton v. Carriers Insurance Company. In the case of Welton, the circuit court held that an insurer cannot evaluate a claim or inform a claimant of a decision unless a claim for a specific amount of benefits has been submitted to the insurer. The circuit court went on to state, and the Supreme Court adopted the notion that an insurer must have a basis to evaluate the claim and assess potential liability. If the insurer does not receive that basis to evaluate, how can an evaluation be done? How can the claim be adjusted? This is a logical following of MCL 500-3107, which requires payment only for charges that are actually incurred. Therefore, when no reasonable proof is submitted to the insurer, there's no basis for the insurer to adjust, assess a claim, and no way to know what charge has been incurred if there's no reasonable proof of that charge. Another on-point case is the case of New Start, where the court found that plaintiffs failed to provide reasonable proof of the fact and the amount of the loss sustained, despite information in the defendant's activity log regarding conversation between the claims rep and the third-party case manager for the plaintiff. The information provided within the complaint and the attendant care provider's affidavit is not enough to provide reasonable proof. This principle is more recently recognized in the Michigan Supreme Court case of Douglas v. Allstate, wherein the court noted that the most appropriate means of providing reasonable proof to an insurer is to submit documentation, whether a formal bill or a memorialized statement log, with specificity of the nature and amount of services rendered. Based on these principles, and given that there was no basis to which actually assess the plaintiff's claim, the plaintiff in New Start failed to fulfill his duty of providing the insurer with reasonable proof. Thereafter, the plaintiff's claim in New Start was dismissed. Motions for summary disposition are appropriate on this issue when you have those cases such as a hit and run, or a case where a plaintiff does not have a police report and has no other independent verification. So no police report, there's no other driver that hit you, there's no damage to the vehicle. In cases such as those, it's appropriate to file motions for summary disposition, as there is no reasonable proof. If there's no proof that there was ever a loss, there's no proof that the charges or bills or attendant care were incurred. Also, in cases such as those, it's important to do your due diligence as the defense or the insurer to order the police report in the city the plaintiff alleges the accident took place, and neighboring cities as well. It's also important to maybe get a biomechanical engineer to determine if the accident ever took place, or like plaintiff alleged it did. Those provide additional support for motions for summary disposition on this issue. And that is all I have for today. Thank you guys so much for attending the May 2021 episode of my PIP Monthly. Again, my name is Amber Holloway, and I'm a partner here at our Troy office. Please feel free to contact me with any questions and concerns.